video in litigation, I thought it would only be appropriate to talk about appeals. And really I'm going to focus on appeals from Magistrate Small Claims Court, because if you're appealing a case from state or superior to the Georgia Court of Appeals, or then to the Supreme Court of Georgia, most likely you have an attorney and you're taking that attorney's advice and learning from your attorney, not from a 2-minute appeals video. Let me say it this way. If you're getting all of your knowledge about appeals to the Georgia Court of Appeals, the Georgia Supreme Court, or the 11th Circuit Court of Appeals for federal cases from a 2-minute appeals video, then you need to turn this video off right now and go contact your attorney. Let's talk magistrate appeals. So let's say dealer loses in Magistrate Small Claims Court and thinks that they were wrong, that the decision of the magistrate judge was wrong, okay? Or maybe right, but picked the wrong number and awarded an incorrect judgment, or for whatever reason believes that something happened in the case that shouldn't have happened, or just wants to get it heard by a new judge. One of the neat things about magistrate court in Georgia is that the losing party, or even the winning party, if they don't win all the amount they think they're entitled to, has an automatic right to a de novo appeal. Now, it's another Latin phrase, right? De novo, which really means from the beginning. And what that does is the losing party can appeal to the state or superior court, where they get to start the whole thing over with no preconceived decision by the judge, meaning the state or superior court judge doesn't get to rely on the magistrate judge to say, oh, if the magistrate judge found the defendant guilty and awarded judgment to the plaintiff, found in favor of the plaintiff, then I should too. Not the case in these appeals. They have to start from scratch. Now, a couple conditions there. Some judges will go ahead and put the case right onto a trial calendar and say, look, if you didn't get discovery in magistrate court, you don't get discovery on an appeal either. However, the parties can request a discovery period in an appeal. The other thing to keep in mind is that an appeal from magistrate court does not broaden the amount of jurisdiction given to the state or superior court. Meaning, magistrate court, you got a $15,000 limit. If there's an appeal to state court for a case that was originally filed in magistrate court, that party or that case doesn't all of a sudden have some unlimited limit. It's still limited to the original jurisdiction of the magistrate court, $15,000. Now, one important thing to note on that topic. Let's say the plaintiff files a claim for $10,000 in magistrate court, but for some reason, the defendant has a counterclaim that's worth $20,000. Well, the magistrate court cannot issue an order or a judgment for more than $15,000. So if that happens, then the case automatically gets kicked up to the state or superior court, similar to an appeal. It gets moved up there because there is a claim in the case that is over $15,000. So that's, to sum up, kind of the end of litigation. If things don't go well, there is the appeal from magistrate court up to state or superior, where there's essentially a do-over. Now, something to keep in mind we didn't touch on, but I want to end with this. Companies, registered entities, we talked about that way back at the beginning of the program. Registered entities do not have to have an attorney represent them in magistrate court. So small claims courts, a full-time employee can go on behalf of the business and present the case to the judge. That is not the case in state or superior courts. This may be one of the most important things I talk about, so I saved it the best for last, right? In state or superior courts, the business as a party must be represented by a licensed attorney licensed to practice in the state of Georgia. So that can sometimes be a deterrent, meaning it can be a big problem, frankly, for a lot of smaller dealers, or just dealers in general, right? That, look, I don't want to have to hire an attorney to do this case. So I'm going to go to magistrate court, keep the case under $15,000 so that I don't have to pay an attorney. That works both ways, by the way, though. There are a lot of plaintiffs that will intentionally sue on smaller cases in the bigger courts because they know if they sue in a bigger court, even if it's a smaller case, they're forcing the dealer to have to hire an attorney to represent them. So That's the last piece of information I'm going to provide in this video series, and that's that in small claims courts in Georgia, a dealer can represent itself with a full-time employee, any full-time employee. In the bigger courts, the state or superior, the dealer has to be represented by an attorney.